Viewers, welcome to the Personal Injury Law Show. This is a show that talks about anything and everything that's relevant in the world of personal injuries and relates to you, the viewer. My name is Tony Carbone. I'm a personal injury lawyer of over 25 years' experience. With me tonight, I've got a partner of a law firm that's also an accredited specialist in work cover, John Karantzis.
Hi Tony, hi viewers.
And also a senior work cover lawyer in a law firm, Nardine Hanna.
Hi Tony, hi viewers.
Viewers, tonight's episode is a must-see. It's about your rights and protections available to you in the workplace. We're going to be dealing with the case of Mel Gregg, who's suing Southern Cross Media, that is Austereo, for the pranks and all the nonsense they used to get up to.
However, before that, Tony, what's in the news?
Look, there's been a lot in the news, and none more than these boats that are coming from Indonesia to Australia. And what about Kevin Rudd, John, with his massive articles, "You won't be settled in Australia"?
Tony, it's a change in government policy, isn't it? It's a smart election ploy. Basically, he's saying, and the law now is, if you arrive in Australia and you jump the queue, you'll be sent to Papua New Guinea. Simple as that.
Nadine, do you agree with John it's a vote catcher?
A little bit, Tony. It's a little bit alarming to see what type of campaign is slowly being introduced, but at the same time, all the ricochet of these claims with these refugees that can eventually eventuate too.
Do you know, he's been advertising in every paper every day. He's good at spending money, I'll tell you that much.
That's taxpayers' money, Tony.
Yeah, it's a great election ploy.
And the funny part is, it's in the main papers like the Herald Sun, The Age.
Exactly.
I didn't know a Indonesian smuggler would be reading the Age and the Herald Sun, Tony.
News travels fast because the other story is that there's been $60 million worth of damage in a Nauru or Papua New Guinea detention centre.
Well,
so 546 people, detainees, have gone ballistic over what's transpired. And what concerns me, Nadine, is that there'll be plenty of people getting injured out of this.
Well, it seems that it would fall part and parcel. If there's been $60 million worth of damage, we would be almost assured that workers and asylum seekers would also be injured in such a catastrophic disaster.
A lot of claims will come out of this, Tony. Security guards, people employed at these facilities, if they're injured, they suffer stress and anxiety as a result of this rioting. The Commonwealth government will be liable, won't they, Tony?
And John, definitely. The big concern for me is there's been a lot of cars burnt out in buildings. So we're talking about here people with severe burns.
The Commonwealth and the occupier are required to provide safe workplaces for all these security guards, all personnel working. Now, if you've got detainees rioting, causing these issues, well, it's a clear-cut case, isn't it, Tony?
I think so. Yeah. I mean, they need enough staff to be able to stop the riots, and who knows, they might even have to send in the military. You just don't know.
And assistance. I understand that one security guard is responsible for 300 to 400 detainees.
Yeah, it's a pretty tough gig.
It's crazy.
And the amount of claims that we have seen in these types of instances as well has been astronomical. So there's no doubt that there will be a lot of media and coverage coming through with that too.
There's this slogan in yesterday's Sun front page that really caught my eye. Victoria's most powerful men declare war on family violence. They said, take a stand.
Take a stand.
That's a catch cry that you and I are familiar with, aren't we, John?
It's take a stand. We say everyone that's injured in personal injury, they should take a stand, make a claim, see a lawyer.
And don't be scared. Don't be scared because you think that you're going to be out of pocket, because at the end of the day, when you sit down and you know your rights, you'll find that you won't have to worry about someone chasing you for fees.
No.
Because you'll be chasing them for fees, isn't that right, Nadine?
Exactly right, Tony.
John, schools excel in mental anguish. What's this all about?
Tony, we've seen an explosion of stress and anxiety and work-related injuries arising at the school place. Teachers, they've been bullied, they've been harassed, either by students, by their fellow staff. It's exploded, hasn't it, Tony?
It's out of control because, I mean, the reality is when I was at school many, many, many moons ago, you know, teachers were allowed to hit you with straps and all sorts of things, which I don't condone.
No.
And I wouldn't want that to happen to any children these days.
Not at all.
But if you get some kid that's totally out of control and they turn on a teacher, how do you deal with it, John? It makes it pretty tough.
And these kids these days, Tony, they can get very physically violent. Not only do you suffer from stress and anxiety, but there's actual physical violence involved.
Exactly.
And then what would the school do? Because you would often see these teachers making these complaints about specific students and pupils, but the school wouldn't necessarily reprimand the child in the appropriate way, and hence these massive payouts that we're seeing because of the psychological distress of the teachers that are occurring.
And Nadine, I don't think they're allowed to expel the students until they're 16 anyway, so
Well,
it makes
that's
it pretty
right.
tough.
There's exactly right.
In the end, Tony, we've got a situation where, again, the school in itself is a workplace. The school is required to provide a safe workplace to all teachers and all staff working there.
Exactly.
Now, if you've got these out of control students or even out of control staff working there, well, they have to be get rid of, don't they?
What about surveillance cameras? Do you think that is a breach of privacy, or would that assist in keeping people in check?
Well, I think it could be I think it depends on the nature and the extent of what is going in the classroom. If there are serious students that are causing a muck and they're known to be difficult students, then, well, I think the school has to be quite cautious in how and when and what is appropriate to put the cameras in place.
Exactly. John, let's go on to the next one. Health deaths probed by the coroner. The coroner's investigating 4 deaths involving these ambulances that are getting to the scene late.
Yes.
And the reason why I raise this is because a very good friend of mine had a massive heart attack last week, but the Mikey ambulance got there in 8 minutes and it saved his life.
Well, 8 minutes is fantastic, Tony, but unfortunately it's very unusual. What we're hearing stories and reports of is the ambulance not turning up at 8 minutes, but turning up at 25-minute mark.
Well, in Meetung, John, just on that point, Nadine, a 66-year-old man had a heart attack in Meetung, an ambulance took 24 minutes. I mean, he's not going to survive. It's too long.
It's sad, and we've been seeing that the ambulance have been arriving late, but even then, when the ambulance do arrive at the hospitals as well, Tony, there's been a massive backlog in the waiting rooms, as we saw in the Frankston Hospital a couple of weeks ago as well.
And we've previously discussed this, haven't we, Tony? The government needs to put more money into the ambulance system.
And that is one service that definitely needs resources.
Ambulances
Definitely.
and the hospitals. We've said it time and time again.
Okay. John, your favourite captain, Captain Scatino.
Oh, he's back.
Yeah, what's he up to now?
Tony, the hearing is happening in Tuscany, Italy at the moment. He's charged with manslaughter and all sorts of charges. He says that he inadvertently fell into the boat that took him away from the boat.
And landed in the lifeboat. Is that plausible?
I wouldn't know where to begin to think about this type of case.
The poor fella. It was inadvertent, Tony.
John, is it beyond reasonable doubt, like in Australia, the test?
It's actually on the balance of probabilities, Tony. Yes.
Well, it's probable that he could have tripped and landed in a boat, surely.
Well, it is. Yes, he tripped because he was running towards it, Tony. That's why. He was getting out of there.
I think one of the funniest things, and it's not even a laughing matter, because so many people died,
Exactly.
is the fact that he wouldn't get back on the boat. When the Coast Guard was saying, what are you doing? Get back on a boat.
No, apparently his girlfriend was holding him, stopping him from getting off the boat, Tony.
Oh, she was on the same boat, was she?
That's my understanding.
Oh, gosh. Anyway, viewers, we're going to have to go to a break now. Before we go, we're going to be talking about Mel Gregg's case against Southern Cross Media and Austereo. So please stay tuned. This is a very interesting case that affects most people in the community these days. Viewers, welcome back to the show. Before the break, we're talking about Mel Gregg's case against Austereo and Southern Cross Media. But before we get into the facts of Mel Gregg's case, John, tell the viewers what is general protections law, because it affects everyone, employers and employees alike.
Tony, it's a Commonwealth piece of legislation. It covers every employee and employer in the whole of Australia. It's under the Fair Work Act 2009. Basically, and in essence, Tony and viewers, any employee that's suffered some form of discrimination at work, some form of bullying, any type of conduct which is detrimental to their work, they have a claim.
And the key words that they use is anyone that's experienced an adverse action.
Adverse action, exactly.
That's right.
Now, Nadine, let's get back to Mel Gregg. Tell us a bit about her case.
So this is the famous case where two radio hosts from Sydney had contacted the London hospital and played a prank on a nurse trying to get information about the royal family at the stage.
Yeah, it was, John, they did a good job because she got coaxed.
Well, look, the nurse involved was coaxed, gave out that information, but unfortunately, and no one could foresee this, could they, Tony?
It's totally
The
unforeseeable.
nurse has committed suicide. She had a lot of problems herself, and she's committed suicide, and there's been a massive amount of furore ever since.
Just on that issue, it just shows you how many people in society have got serious psychological, psychiatric problems.
Exactly.
And it astounds me that even family members aren't privy to that information, because we've really got to be wary, don't we? Because people could be suffering in silence.
That's right.
And how one incident can literally push someone over the edge.
Exactly.
Now, but this has occurred, and the prank has basically been exposed worldwide, hasn't it, Tony?
It has.
And now these two DJs, well, one, the male DJ, he's kicked on with his life.
Yeah, he seems to be travelling okay.
Exactly, but the female DJ, Mel Gregg, she's still suffering from stress and anxiety.
Yeah, look, judging by what I've seen, she does look like she's pretty severely affected from a psychological point of view, don't you think, Nadine?
Well, yeah, absolutely. It's unfortunate that her phone call and the telephone call had, as John had said, it was unforeseeable that a suicide would occur. But I wouldn't blame that Mel Gregg would be suffering from this type of psychological
well, she obviously
reaction
feels
from
guilty
this.
for what's happened,
That's exactly
although,
right.
strictly speaking, unforeseeable, John. But Mel Gregg's claim's pretty strong, I would have thought, because at the end of the day, it was an unsafe workplace, wasn't it, John? What's that mean?
Well, exactly. What's happened is basically she has refused to go back to work. She's rejected all offers from her employer, Austereo, to go back to work because the understanding is that she still continues to suffer from stress and anxiety. Now, she's instructed lawyers to issue proceedings pursuant to the Fair Work Act under the adverse action model, Tony. Now, basically, she, as part of the allegations, is that the employer has not provided her with a safe workplace.
Well, the adverse actions, in this case, I would have thought, Nadine, are getting them to prank people, actually encouraging pranks that are so hideous. In some, one example is them getting on air saying that a senior presenter had been killed in a car accident, which wasn't true. I mean, who does that? That's immoral, apart from anything
So we're
else.
talking about an organisation that allows this type of culture, this type of prank to occur, don't we, Tony?
Exactly.
Even if we were to extrapolate it, moving aside from, say, a radio host, say if anyone in the general workplace was to play a prank and to condone these type of activities, it's just never called for, I would think, boys.
Exactly. And look, this is also a lesson to all employers out there. If you've got a young apprentice or someone that's an easy target, and you allow your people to pick on them and carry on, I'll tell you what, under the Fair Work Act and adverse action, general protections, they can easily come at you. It's not a hard claim.
Well, what you have to show as the worker is that you've suffered a form of discrimination, a form of, in essence, adverse action against your employment rights.
Just bullying.
Yeah, it could even extend to simple bullying. Now, in this case, the claim is subject to conciliation under the Fair Work Act. You'd think this would settle, wouldn't it, Tony?
Yeah, it should settle. Look, it's a no-cost jurisdiction, but having said that, the court's got an unlimited jurisdiction to award.
Let alone the fines that could be payable by the organisation as well, so it's quite hefty in this
So
type
what
of
we're talking
jurisdiction.
about there is she's got a claim for economic loss, past and future.
Exactly.
Which is unlimited.
Exactly.
So that could run into the millions, Tony.
Could run into a lot of money.
And then we've got a claim for pain and suffering. That could be easily $300,000-$400,000 easily.
And also medical treatment.
And medical expenses.
You've had a bit to do with this, haven't you, John? General protection,
Yes.
Nadine, the two of you have been
Exactly.
A little bit.
And on top of that, the Commonwealth, the Fair Work Act, can fine the employer $51,000 for each breach of the Act.
It's quite significant.
It's
Isn't it?
is,
significant.
it is.
Let's say there's 4 or 5 breaches, that's already $200,000 in a
Exactly.
fine.
Exactly.
So employers out there, be wary. You can't allow and condone work practices which adversely affect your workers.
Exactly.
And on the other hand, workers, if you're suffering from any form of discrimination, any form of ill treatment, if you've been demoted to another job in the area, and that's clearly a demotion, well, again, you have a claim.
Let's get on to this case of a bookstore bully where the court awards the employee $600,000. Nadine, tell us a bit about the facts of this.
Well, it's a story of this relatively younger type of lady working at a Monash University book site, and there had been years of worth of allegations of bullying, and even then her employer had been noted to have thrown a book at her head, and the court had awarded her $600,000 of pain and suffering damages and economic loss damages. So it's quite a significant case in this jurisdiction.
Tony,
What's the breakdown, John?
Tony, I think this is the most significant case in bullying of our time. Tony, Justice Dixon of the Supreme Court has written a 50-odd page judgment. It's a very, very detailed judgment. It's under appeal. However, my reading of the case is I think this will be looked at. This will be a precedent, Tony. Basically what it's saying is any employer that allows any form of workplace bullying over a continued time, we're talking years, they will be liable. Tony, I think we have to go to a break. We'll get back to this after the break because I want to talk about it.
Viewers, stay tuned because there's some very significant observations made by the judge. Viewers, welcome back to the show. I said the judge made some significant comments. One thing that I found really pertinent was where he said Mr. Cow, so appropriate, felt no compunction to treat the plaintiff with the level of respect that is reasonably expected. The word reasonably is thrown in there, John.
Exactly, and he's the defendant in this matter. What occurred was the plaintiff, the worker, was working in this small little bookshop, at Monash University. Now, they're working in a small room, and he was making inappropriate comments to her repeatedly literally over years.
Yeah.
One of them was rudely interrupting Miss Swan and belittling her in front of third parties, issuing unreasonable instructions such as directing her regarding how she answered the phone, excessively scrutinising her work, using foul and offensive language. He even threw a book at her. Automatically refusing any requests of Miss Swan and refusing to provide reasons for the refusal, providing instructions without explanation. It's a form of dictatorship, Tony, wasn't it?
Well, the beauty of it for her, Nadine, was the fact that she complained and the board did nothing to stop the behaviour.
Well, that's right. There had been this significant history of these complaints stemming back in 2003, and the board just seemed to pretty
Just
much
ignore it.
They were frozen.
That's right.
They
and
were
didn't take
advising her,
action.
yes, we're looking into it, we'll do something about it, and nothing was done.
And the complaints were quite specific because she said that she was subjected to sarcasm, hostility,
Yes.
rudeness, and violent behaviour. I guess that's thrown in the book.
Well, he also didn't like her eating a banana in the workplace and required her to go outside and eat the banana.
That's insane,
That's
isn't it?
crazy.
Now, we've got a situation where she was a bubbly, lively person. That's her evidence. She was believed. After all these incidences of, belittling over years, basically she's changed and suffered a major depressive disorder. Justice Dixon of the Supreme Court of Victoria, Tony, has believed her, has found her evidence to be credible, and has awarded her $600,000, $300,000 being for pain and suffering damages, and $300,000 being for
Loss of income.
Economic loss. It's a fantastic case, and it just shows that any worker that suffers from this type of literally adverse action, isn't it, Tony?
Adverse behaviour.
At work has a claim.
Viewers, this is a great opportunity for you to get onto Twitter and also Facebook and throw us any examples of any exposure that you may have had to bad behaviour by fellow employees or employers, or circumstances where you've complained to employment or management about the behaviour of fellow employees, especially apprentices where they get these initiations done, and in certain circumstances people have been pretty badly injured. Isn't that correct?
That's right.
Exactly, Tony. But Tony, the key in this case, apart from the clearly inappropriate behaviour, is the worker here was making repeated complaints.
Exactly.
Wasn't she? To
Look,
management.
you do need the complaints, isn't that
You
right,
do. The employer really has to be on what we call notice in the regards of the extent of the injury.
She wouldn't have won, would she, if she didn't complain?
No.
We can't have a situation where the worker is sitting there just taking it all in. You need to make complaints.
Yep. The law won't protect you unless you take the step of lodging a complaint and making the employer aware of what is actually happening.
That's
and,
right.
and following that up. It's no good saying, I made a complaint a couple of years ago. You need to follow it up repeatedly. Otherwise, we've got the case that's always quoted, Tony, the case of Kohler. It's a New South Wales Court of Appeal decision whereby, again, a worker was working under stress, but she didn't complain to anyone about it.
She didn't put the employer on notice.
That's right. She
The
just took it all in.
The employer was not aware of it. So they're saying, they put their hands up. How are we supposed to be aware of what's occurred? And in that instance, the worker did not receive any damages, did she,
Exactly.
No,
Tony?
she lost
So
at the time.
you need to complain about these instances. And I guess at the same time, Tony, we're not talking about, minor things that happen at work.
I don't think throwing a book at anyone's minor.
No.
You could almost be criminally charged for assault.
But you and I, we always get inquiries about people saying, "Oh, he spoke loudly to me." Well, a one-off incident doesn't really constitute bullying, does it, Tony?
No, that's right.
So there is a difference.
There's an interesting story, guys, about the new WorkSafe chief, Denise Cosgrove. She's such a lovely person. She took him to the hot springs out in Dalesford. How good's that, Nadine?
Very lovely, but
No, Tony, she went herself.
No. There's a backhanded...
there was a bit more to that, I'm afraid.
What happened after the nice, relaxing massage and springs and everything else?
Well,
Nadine?
she was kind enough to take her own holiday and then informed, but it seems like it was to be a leak or so by an email of some redundancy that was going to be mass redundancies in the
She
workforce.
sent an email to WorkCover basically saying what a nice holiday she had in... Which resort was it, Tony?
It was down in Dalesford Springs.
In Dalesford, and that, by the way, WorkCover's not travelling well at all, and we have to get rid of workers and make quite a few redundancies. Didn't go down well, did it, Tony?
She said we've got some high-level changes and we've got to look at efficiencies, including people costs, and we're proposing some immediate restructuring and changes to roles, and unfortunately this will result in some job losses. So all of a sudden, so much for their restful weekend, they're all going in a state of panic.
Now, my understanding is, Tony, that the Liberal government has directed her to reduce the workforce by 10% in WorkCover.
Okay.
Now, WorkCover, the employees that have been there for 20, 30 years, they're jumping up and down. They don't know what's going to happen.
It is a problem, isn't it?
At the same time, and there's also questions regarding common law entitlements in WorkCover. Now, the government has basically confirmed that nothing will be touched. There's a rewrite of the Accident Compensation Act, the legislation occurring at the moment. It's just worrying because Denise Cosgrove, she actually comes from New Zealand, and she was head of the New Zealand work cover system. And guess what?
It's a no-fault system.
There's no fault.
Exactly.
Yeah.
There is no common law entitlements there, Tony.
And sadly, speaking to other lawyers and people that are in New Zealand, they say that most of the population stay on the system,
It's a disaster.
and the majority are so depressed into the future.
It's a disaster. And this harks back to the bad old Jeff Kennett days when he got rid of common law entitlements in Victoria. We don't want that coming back.
No.
We don't want that coming back because remember back then, Tony, we had to advise clients that had lost an arm, a whole arm or a whole leg.
Limited rights.
That, I'm sorry, your claim would have been worth $800 to $1 million, but now because of Jeff Kennett, your claim is only worth $100,000 or $200,000
Exactly.
at best.
Yeah.
Nadine, the first of the general protections case I'm aware of is the David Jones case, McGuinness.
Yes.
That kick-started this general protections.
Reform.
Yes. So I
That's
think
right.
anything else you'd like to add before we go? Because
Well,
the show's come to the end.
It seems that there's a massive window of opportunity for many of our claimants, especially for those that have been on workers' compensation. We really do advise as well
Exactly.
for fair work provisions as well.
Workers, if you've been injured at work, if you've suffered bullying, any form of adverse action, any form of discrimination, you have a claim. You have a general protections claim and a work cover claim. Please see a lawyer. Please seek legal advice. Thank you, Tony.
Viewers, this is directed at the employer. If you condone bad behaviour, mischievous behaviour, initiation rights, any kind of nonsense that is questionable, what I want to leave you with is this. Employers will come after you. They'll get you via general protections, which means you've got no protection via your insurance policy, and it's unlimited jurisdiction. So it will finally catch up with you and burn a hole in your pockets. So just be wary of the law. And viewers, stay tuned for future episodes and always remember to stay safe.